Okay.
Where are you at?
All right, call to order. Roll call.
Perfect. Chair Watson,
Present.
Vice Chair Mahons,
Here.
Member Strong,
Present.
Member Chisholm,
Here.
Member Johnson, Member Hughes, Member Hart.
Here.
Alternate Member Somerson.
Here.
Okay, we do have a quorum.
All right. Approval of minutes. Motion to approve the minutes.
I motion to approve the minutes. They look good.
Move to approve.
Move to approve. All those in favor of approving the minutes from last meeting?
Aye.
All those opposed? None? Cool. Any public forum today?
No public forum.
Code enforcement significant events?
And then as a matter, just to save time, I do know we have a hard stop at 7:30, is that correct?
Ish, maybe 7:45.
7:45. I do need to swear in our new alternate member.
Okay.
And then if we would like to jump down to our unfinished business with the judge and his staff.
We will do that.
And then we can catch up with the rest of the stuff
Yep.
later, if that's okay with the board.
That works.
We can go ahead and do that. So, great, I can just
Go
go ahead to stand and raise your right hand real quick, get you sworn in. I, Rick Somerson,
I, Rick Summerson,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution of the United States,
that I will support the Constitution of the United States,
the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
and the Charter and ordinances
and the Charter and ordinances
of the City of
of
Englewood,
the City of Englewood,
and that I will,
and that I will,
to the best of my ability,
to the best of my ability,
faithfully perform
faithfully perform
the duties and offices
the duties and offices
as an alternate member
as an alternate member
of the Code Enforcement Advisory Committee
of the Code Enforcement Advisory Committee
during my continuance therein.
during my continuance therein.
Perfect. Congratulations.
I know.
I'll get you the sign at the end.
Okay, perfect.
Formal. Okay.
Thanks, guys, for having me. I'm Joe Jefferson. I'm here from the court. I was just telling Rick before we got started here, we don't get invited to too many parties, so we appreciate an opportunity to be heard a little bit tonight. And I'm going to introduce our court administrator, Kenitha Julian. She's our fearless administrative leader. I thought I would have her introduce a little bit of background about what we do and why before we jump into the weeds of Title 15. I made an effort to just look at your guys' agenda and watch your last meeting just to try to hit the spot, and so I'm trying my best. But if it's not exactly what we're looking for, feel free to try to make this a conversation and jump in and ask questions, and we can kind of redirect this as we go, okay? KJ, take it away.
All right. Again, reiterating, thank you for having us, but we know you know civics, but we just wanted to reiterate, just as a reminder, that Englewood is very fortunate in that it was built under the same concept as the U.S. Constitution, and that there are the three separate branches of government. Although we do intertwine at times, and we're all under the realm of all of the citizens within Englewood. But we have our executive branch, obviously, that does the enforcement, which is the city mayor, city manager and mayor, as well as the police department, and then our legislative who, with the city council, create public policy, create our laws through our charter and ordinances, which you all are a subset of that, obviously, helping to put some of those things together and give that feedback to council. And then obviously the judiciary, again, separate branch of the government, and we have our elected official as well. His job is to interpret and apply the law. And again, I think the forefathers of Englewood were very forthright in their sight, because it has been a very beneficial aspect to have an elected official. It really does help to focus on that justice and that public safety by saying the judge can't be pushed to do certain things because city wants them to, and vice versa. Judge can't get any of the other branches to do the things that he does. Again, we have some overlap with our budget and those types of things, but we all work together for the justice and public safety of our needs. All of that also increases public safety and public trust. With us all working together, having that communication, being able to communicate, come out, have sessions like these, as well as the community knowing that we've all had that input, it does build that public trust out into the community. We also remind you that we don't pick our cases. The cases are what comes to us, whether it be from code, the police department, and what the city determines, the city prosecutor determines that they can file in the court. And with that, the court then oversees those cases. We are limited in our jurisdiction to 365 days and $2,650 in fines. We do have speedy resolutions in that our cases with a speedy trial time is 91 days. And so when you look at us and you look at the judiciary within the community, we are a convenience. We are local to the community. People don't have to go all the way out to Peoria. We have a deeper understanding of the community. We realize what are unhoused and what we're dealing with. We realize our mental health challenges. And with those, we've been able to incorporate some of our programs, of which I'll get into probably in our next slide. So it's a very good opportunity for us to have a court within our community and have these separation of powers so that everybody can get their jobs done and build that trust with the community. And with that, we as a court have created our own missions, values, and goals in that we are ensuring that we have justice with dignity for all, so that when citizens of any aspect of life come to us, we make sure that we are impartial in our sentencing and our delegation of that authority. We are accountable to the citizens as well as to the laws and to the other branches of the government, and making sure that we recognize those laws, understand them, and interpret them just and impartially and fair. We are welcoming and also respectful of all that come into our court, whether it be our stakeholders, our defendants, whoever may come in. And again, all of those things go back around to building that public trust with the community. Our goal is to safeguard individual rights. We want to make sure that the Constitution is upheld and that people are entitled to their due process and all of the rights that are entitled to them in the justice system. We do that by providing efficient, effective, and fair service, making sure that, again, that 91 days is looked at. Whenever we can do effective, we now have our online portal in which people can pay their tickets right away, or if they do have other sanctions, they can report those through the online portal. And then promoting rehabilitative and restorative opportunities. We have been fortunate to develop our restorative justice program as well as our court navigation program, which again, knowing the needs of our community and the citizens within ours that we serve, it gives us the opportunity to be very strategic and individualized in our sentencing strategies. If someone, we recognize they have an addiction issue or they have a mental health issue, jail may not be the place for them. They actually may need some of the resources, and through these programs, we're able to get them connected where they need to be. That doesn't mean that there aren't times that jail is an appropriate sanction. You know, when it comes to public safety, we are making sure that we do sentence people to jail or the time that's necessary, and those types of things. We collaborate with our community partners, again, for those resources, also for community service aspects. We also have collaboration with the jail, with the various counties. I'm proud to say that we are able to do more virtual hearings with counties outside of Arapahoe in order to facilitate a lot of this timely and efficient resources for us to get our cases resolved and for the defendants. And then again, all of that together, enhancing that public trust and then also public safety, making sure that we're keeping our community safe and protected in the ways that we can. And again, not always jail, there are always the alternative sanctions as well. Anything to add, Judge?
You know, that was an amazing overview. I'm going to take us one slide back and just try to highlight a little bit more about how this body, the Code Enforcement Advisory Committee, sort of fits into all of that. You know, just to comment a little bit about what she just presented, I think that this separation of powers here in Inglewood really does help maintain public trust, knowing that we have a truly independent court who is represented by the elected judge, because that is a very unique thing in Inglewood. I'm the only publicly elected judge in the state of Colorado, if you can believe that. Most of them, you know, have are hired by contract or appointment by the mayor or the council in their municipality. And so a different version of separation of powers exists in most municipalities in Colorado. And so we think that that's worth highlighting, and that this model, I believe, has served us well. One of the other things to note is that our court has exclusive jurisdiction. We're the only court in the world that can handle Inglewood Municipal Code violations or Inglewood Municipal Charter violations. While we do share what some folks might think of current jurisdiction with state law, every case we hear is a violation of our code. And how our laws go, I was just talking to Rick before we got started here, is, your guys' role in that is super important, because in my mind, the community values need to be reflected in the law and vice versa, right? And I feel like you guys are a really integral conduit between the code itself and the people, and making sure that those generally match up. And so I appreciate your guys' effort. In an effort to kind of think about what we were going to present today, I took a look at these authorities here in the top right. The purpose and duties is outlined by Inglewood Municipal Code and by your bylaws, and essentially they highlight mostly the same things, and that there's sort of some major duties of this body. One of them, of course, is to conduct ongoing comprehensive review of the municipal code, and I'm going to try to, and I tried to take each of those enumerated areas in your guys' power and duty and match them to the code in this presentation. And so hopefully you guys will help, that'll be helpful in your efforts to review some of that code. And then of course, this committee makes recommendations to the city council for addition, deletion, revision of the provisions. Secondarily, this body reviews the processes and procedures of the administrative functions of the code enforcement body and the police department, and makes recommendations to the city manager on those enforcement efforts for improvements. Thirdly, this body seeks input from the community and develops community education efforts, and I genuinely appreciate that. And then finally, this body is the conduit of communication between the council, city manager, and the community, and makes an annual written recommendation to all stakeholders as needed, but and at least annually. And so that I felt like might be a helpful just kind of overview of kind of what's contained in both the authority of your body, but also the duties of this body. And I know that the city council is taking a look at Title II at this time about all the different responsibilities of all the different boards and commissions. And so, now might be a great time to give any feedback to Rita if there's any substantive changes that might be appropriate. Any questions about the separation of powers or how this body fits into it? And so in my mind, your body links more directly to both the executive branch for feedback on the enforcement activities, and also to the legislative branch for feedback on policy or the local laws. And of course, we're all ears as well here tonight, honestly.
Can I ask you a basic question?
Please.
What's the delineation? You said that basically you look at anything that addresses a city code violation.
Correct.
So if something happened which was city code violation as well as, let's say, a state law violation, where does that fall? Does it come to your court first and then get referred, or how does that happen?
Yeah, and so there's certain issues that are exclusively local issues, and most code issues, candidly, are exclusively local. There's no state law on some of these animal offenses. There's no state law, I don't believe, on weeds enforcement, if I'm not mistaken. So these are exclusively local and must either be filed with our court or no court at all. And where the state concurrent jurisdiction lies is with more serious criminal offenses generally, right? So for example, if somebody commits an assault on South Broadway, punches somebody walking down the street, and the officer sees that, the officer has some level of discretion whether or not to enforce the law first and foremost, or offer some form of warning is some form of discretion of law enforcement that's really critical in any criminal justice system. And then secondarily has the discretion of what venue to file the case into if the action is both a violation of state statute and of local municipal ordinance. And sometimes those penalties can be different. And in fact, the state is somewhat divided at this moment, and there's a case in our state Supreme Court on this exact issue on whether or not penalty differences between the state statutes and the municipal ordinances are an unconstitutional violation of the law or a reasonable exercise of home rule authority as promised in Article 20 of our state constitution. And that is, in the legislature as well, and they're sort of fighting like cats and dogs at this moment on these issues. And so, does that answer the question?
Yeah, I mean, I imagine there's a little bit of a gray area there, and that, there's some discretion that happens with the police department determines whether it should be kept here, or whether it should be kicked up. I think what you're referring to is that sometimes, I think some of the penalties at lower levels are higher than the penalties at the state levels or something.
Correct.
There's kind of a weird mismatch there in terms of how that's being carried out right now.
Yes, and I don't know that it was necessarily by design by anyone, right? It's that our systems organically grew differently. Because of the home rule authority unique here in Colorado, these municipalities have very different sentencing structures and systems than the entire state system. And there was never, to my knowledge, in Colorado, ever any attempt to mirror these two systems like in other states. Texas is probably a great example where municipal courts are part of their state court system and handles decriminalized issues of state statute, and there's no such thing as this kind of, issue.
Okay, that helps.
So,
thank you.
for example, a case, just as an example, like cruelty and neglect to a dog. We have the option for a simple cruelty, say a dog was left out in the cold. If it was left out, if it's intentional, they left it out as a form of punishment, we can go municipal or we can go state. If we go state route with the DA's office, a lot of the times because of caseload, if it's a very minor state violation, that most likely could be dismissed, or it may not go all the way where we want the prosecution. If we go municipal, we do have more options for restorative justice. We do have more options to keep it in-house, to follow it, to make sure that that case is actually followed through with. So we do have the option to go municipal or state. In that case, we're going to keep it municipal so we can follow through with that 100%. Now, same case, except we have a previous offender. We have a horrible case of cruelty and neglect, intentional, with lots of previous cases. That case we may push through state because we do want those harsher penalties of possible prison time because of previous cases. So same charge, but different situations where maybe municipal is better versus state.
Okay, so I have a question on that, and I've never been quite clear on this. If you have, there's a change being made now, a bill going through on the state level to, if you bring in a load of puppies, put them on a corner at a pen to sell them, they're making a state law that that's illegal, and you would get a ticket on the state level, and would be against state law. That would not go to municipal court. You can't hear that case. That would have to go to.
Correct, unless our council adopted their own local ordinance on that issue. And as long as it's not exclusively statewide jurisdiction, like felonies are considered to be because of the state interest in keeping track of serious crimes across the state, or, things like, driver's license issues, right? Because the state's issuing the driver's license. They have exclusive jurisdiction on those types of issues. But on an example you just mentioned, that sounds like a mixed issue where our council could make it also illegal under the municipal code and file that case with our court if the city so chose.
Right, and it's my understanding the cities can make the laws more restrictive than the state, but they can't make them less, correct?
Yeah, one way I think of it is that the city cannot allow something that the state has expressly made illegal, or make something legal, or vice versa, make something legal that the state dictates. So when, for example, when the state and the voters legalize marijuana, the city can't criminalize possession of marijuana in conflict with the state law, right? And so that's really where that is. And some people might argue that the penalties are, conflicting, but generally the case law sticks to, as long as, one version of the law doesn't forbid what the other allows, that's the conflict they've generally analyzed in the past, not necessarily the sentencing issue. And so that's why we're all kind of interested to see, what the results of that might be. And some of it is just overly simplification, right? On the municipal side, we have a much more simple system. We have a general penalty provision here in Inglewood under Title I, which defines that any violation of Inglewood Municipal Code essentially is punishable by up to the maximum of our city jurisdiction. Whether or not that's a good idea moving forward, I'll leave to the infinite wisdom of our council. But that's how we've been for a very long time here. I mean, probably since '59 in my mind, since we became a home rule municipality, that's how we viewed that. And that the discretion of sentencing was always left to our elected judge, and that served us well for a long period. I sense now that, we're in an era of, some questions regarding centralized authority and positions of authority. And I think that's wholly appropriate. And, maybe there needs to be some limits to that judicial discretion for certain types of offenses, like code offenses, like you guys deal with, right? Maybe those should be not jailable. Maybe those should be limited jail issues, because essentially, because of our simplified system, everything sort of points to this very simple sentencing standard. And the state system has 1,000 pages of different, sentencing guidance on, every different type of offense or levels of offenses. And maybe I've seen some municipalities who have created different tiers of offenses, right? These ones are subject to the max because those are crimes against people like assault or menacing or harassment or something in that range. And these are decriminalized where only a fine is appropriate because it's weeds in your yard or it's something else that has limited public safety impacts. And that could give guidance to our court, right? And to our judge in the future about what is an appropriate sentence. The reality is, though, we've had this authority as the court for a very long time, and we have some idea of what we think a reasonable sentence should be, right? And trying to make sure that people are generally treated fairly and equally when they come in front of us. And we're somewhat aware of, what does a normal sentence look like on this type of a case. It's, not formalized into the code, but rather a function of the discretion of the judge. Go ahead.
This is probably an extreme example, but sentencing, let's say it's a city code violation, but let's just say it's my neighbor who is absolutely notorious for pushing the limits, being difficult. And in my example, when I lived in another community, I had a neighbor like this. So, anyway, so
just for the record, not as current neighbor, not a
with no names, but this guy was really extreme, and he made a game of it. So that if you said, okay, you have 10 days to address it, he'd wait until 9.5 days. And if you said, okay, your fine is $30, he'd probably pay $29.50. Anyways, if this kept coming to you, and you said, this is not normal. This person has an issue or a problem, or can you escalate it? Or, what would you do in a situation like that?
Yes, most certainly, and that's, by leaving that level of discretion to the judge, the judge can increase over time the sanctions and the supervision over compliance with the court orders moving forward. And so, we have generally review 4 years plus current. So we look at what the last 5 years of the history generally at the sentencing. Ancient history sometimes, either gets discounted or maybe removed. Sometimes we will self-purge our records, and that's why I kind of described it as a 5-year kind of look-back period, is because we'll start to purge some of those records over time. But we're certainly aware of, in my mind, the unique circumstances of the violation, whether or not they had prior offenses, whether or not these are egregious violations that are impacting the neighbors. Those are all appropriate factors for sentencing. And, the city is represented by the attorney in every case that KJ talked about, and that's our city prosecutor. And the prosecutor, at sentencing makes recommendations to the court and is in good communication, hopefully even better moving forward with our police department and with our code enforcement department and hearing those feedbacks from the neighbors. Finally, as a victim or an interested party in the case, you always have an opportunity to directly write to the court or be heard at sentencing. Sometimes that's a little bit difficult, particularly on minor code issues, but that is a possibility as well.
Thank you.
Yeah, thank you. Appreciate your guys' interest in these topics. Anything else before I move on? And so I'm going to try to cover today mostly Title 15. That seemed to be the focus of kind of where you guys had left off and what you guys were talking about. And so, we'll try to just, start with, the definition of nuisance, which is a really long definition in our code, and essentially defines as any ongoing violation that endangers public health, safety, or welfare, or any other ongoing violation of our code or state law. I mean, it really is this kind of catch-all, and whether or not that's too broad or, not broad enough, I guess I'll leave to your guys' discretion. But, I wanted to just start by saying that, nuisance is a really broad categorization of ongoing offenses that negatively impact those areas I've talked about. And we'll try to cover some of both the enforcement procedure as well as some of the appeals procedure, as well as some of the court procedure. And hopefully that will give you a good backdrop, and then we can continue some questions on some of this stuff. So we're going to start with, nuisance enforcement, and AJ probably is the subject matter expert in the room, and so I'll probably defer to him a little bit, but I tried to put this out a little bit visually. I just felt like this might be a good way to explain a little bit of this procedure. And then as you guys are reviewing the language, from a layperson's perspective, do the citizens understand, what's in here? And, can we match it up to what we conceptually think it should look like, right? Might be a healthy exercise as well. But I wanted to start just from a really 30,000 foot level conceptual before we, get into the weeds of any of the language. And, really that begins with what's called inspection, essentially, or, anytime the enforcement officers notice some form of a violation. And at that moment, there's, a written report with findings and evidence, gathered at that time. And at that time, the officer has an opportunity to make a decision, like we just talked about, under their discretion. And, beginning with that top box, the city manager has authority under 15.3.1 to abate any nuisance in the case of an emergency, essentially without any procedure. And this, I've seen other municipalities handle it differently, but this offers our municipality pretty broad authority to deal with a nuisance if it's defined as an emergency. And an emergency is defined by our code in the very previous section as an existing condition actually arising from an unforeseen contingency. An existing condition actually arising from unforeseen contingencies which immediately endangers public property, health, peace, or safety. And whether or not that is the appropriate definition to allow for that executive authority without a check from the third branch, I'll leave to the wisdom of this policymaking body and of course of our council. I'm not, AJ, maybe you can speak to how often this authority is used. I know it's pretty sparing, but any thoughts on the emergency option before we move on to the other option? And feel free to correct me if I'm ever off base.
So the last time this was used really widespread in the city was West Nile. When that came through, there was actually forms that we had that were printed up by direction from the health department and all that, where any standing water on property was considered a hazard source for West Nile. So as code enforcement, as police officers, we would actually fill out a form on this date, this time. It was a pre-done form. We entered date, time, we signed it, we would leave a copy on the property, and we would go dump out planters, we would dump out buckets, anything like that, and that was considered emergency abatement because that was under a public health order at the time. More recently, emergency abatements like we talked about would have been the bomb house that we talked about in past meetings, where that was boarded up, that was done under the emergency abatement authority for that securing of the property, the board up, and that type of deal. So widespread was West Nile, which hasn't happened in, 10, 12 years. That's been quite a while. So yeah, that's not something that's used very often.
Does that start with you going to the city manager and getting sort of the direction on that? Or how does that usually
It can go both ways. So West Nile was a larger, that was health department coming through the channels, basically, hey, this is coming down. Very similar to right now with the avian flu. There's a process that the city is aware of, we're not participating in, but if, say, a backyard flock tests positive, the county is actually the one that would take care of that. But that would be basically an emergency abatement that we would participate in securing the area, where the county would come in and do what they would need to do to secure that scene. So it's planned upon versus like the bomb house, which is a phone call from us in the field up to go, hey, this is what we have. Are you granting us authority to move forward with the securing of the property?
In the avian flu situation, which I think is, you got West Nile over here, you got avian flu, we're kind of rolling in those same territories now. How would that start? Would it be a citizen, reporting that the flock disappeared next door, or how would you know where to begin with something like that?
Yeah, I mean, it could be that someone who has a flock found a dead chicken. They were concerned, so they send off to be tested, or a neighbor found a dead chicken in their yard, or a neighbor found a dead owl, or something like that, and they came back, test positive. Well, county comes out, do their inspection. Well, dead, say, wild bird was found here. 3 houses surrounding it have their own flocks. Per health department recommendations, any flock within so many feet of that dead bird where it was found has to be taken care of. So based on their protocols, that's what they need to do. So that would all come down for whatever their policies and procedures are.
Okay, thanks.
And then moving on to, 15.3.2 and those other 2 boxes, the officer has an option there for an informal abatement by simply speaking to the property owner. Hey, did you know your weeds are a bit long? I appreciate if you took care of that. I imagine AJ has a lot of those conversations. Or, hey, they're unable to make contact with the responsible party and must proceed to the written notice. But, I don't know, AJ, if you want to talk about that at all, as far as, how often that's, used versus the other, or how often you can't get in contact with the responsible party might be an interesting topic.
Yeah, and these are door hangers. These are the 7-day notices. This is the phone calls. These are just more the informal, the conversations that, hey, you're in violation, try to get it cleaned up. This is the calls, hey, the neighbor, all their furniture's out on the front yard, make contact. Oh, we just had an eviction. We have to leave all their stuff on the front yard for 7 days. Great, now we know what's going on. This is more the, like it says, the informal conversation, hey, what's going on? But that does start the timeline of, all right, great, you got 7 days, get it taken care of before we actually have to start the process. If it takes longer, it takes longer, but at least that gets the timer going to go, hey, all right, we know what's going on. Here's your warning, you are in violation, but try to get taken care of.
And then, both of those roads sort of, well, I guess at the end, if he has contact, in an informal way, at the end of that period, the officer has an opportunity to write them into court or to escalate it through a written notice, which also leads to court at the end of that rainbow. And the written notice form is highlighted in 15.3.3 that shows sort of the essential elements of the notice. And I know you guys have looked at some of those notice documents recently, and I appreciate your guys' efforts there. Any questions about, getting us through the notice period as far as, when there's either no contact or that informal abatement has reached its end? And so, we describe how that written notice is served on the party, either by leaving a copy at the residence or the business, or by mailing it with the returns receipt, or by publication as well as an option for the city. Then we move on to, after that written notice is done and there's no response, the city has yet another decision it can make, and that is to execute an administrative abatement at that point, or file it with the court, or both simultaneously. And I know that the city's been providing some reporting on administrative abatements more recently, and that we've seen a bit of an uptick as far as use of the administrative abatement option versus filing of summons and complaints. And of course, that is, again, the city's discretion of how to use those tools. But, I do note that, we have seen a drop, I think, in, total number of summons and complaint cases and an increase in the use of the administrative abatement option. And, again, that's, wholly appropriate, and I see that functioning fairly well, in a lot of weeds cases. But again, appropriate for your guys' feedback about, is that meeting the community standard? Is that what we want? And I will say that, this was a relatively large change, probably a couple of years ago, AJ, in my mind. We've brought a couple of years of history, I think, of this to look at. And I know the city's been providing some good information on that 2024 annual report and things. And I appreciate, AJ, your efforts with that as well. AJ, anything to add there on the last sort of box?
The only difference I would say is your top summons and complaint to court. Unless it's an egregious situation where you've already been to court, we will always, as a courtesy, go with the 14-day notice. So we will not go straight to summons and complaint unless they've already been through the court process, or unless they've already received the written notice. So like the grass and weed notice, that the official notice, the 14-day posting that we've already gone through this process, they would have already received that. So we don't skip on that 14-day process. The informal process, the conversation or something, if we can't get a hold of them, we may skip that informal process, but the official 14-day posting that's in municipal code, we will always do that regardless of the situation, unless the property has already been through the court process and it's under like a conditional suspension or somewhere where it's already within the court. Then we'll go straight to a new summons because the property's already basically under probation. Otherwise, we will always, that written notice is always issued to the property by one of those means. So that's really the only difference that we do follow.
Appreciate all that. Other questions or comments regarding this slide, perhaps before we move on? And we'll pick up this administrative abatement appeal as well as the court process in another slide. But any other questions regarding this process? As I know that this can be, cumbersome language. KJ and I debated, do they have this option at this point or not? You know what I mean? And so we hashed it out in our office before we came up here.
So they had to put you through the think process. Now it all works.
Which is probably a good, healthy exercise. The judge should probably know a little bit more about this process. But, keep in mind that, because I'm that separate branch in judicial, I haven't spent a ton of time thinking about this specific process. This is the purview of our code enforcement department on using those, discretionary issues. And so, please, again, don't, try to interpret what I'm saying or read something between the lines. I'm really just trying to present it in a neutral fashion to this body for your guys' consideration about how to proceed on that. We try to, be more opinionated as far as what happens in the court. But, there is impact to the criminal justice system and to our courts on these actions. And so that's where, in my mind, we're not in violation of the separation of powers. If we can just say, hey, if you guys do A, X is going to happen. If you guys do B, Y might happen, and vice versa, right? So we're here really to inform the system, not to try to put our finger on the scale of policy, if that makes sense. Okay. Let's move on to the administrative appeal. KJ.
And this is my area. So the administrative appeal, as you heard, there's the written notice. So once somebody gets a written notice, they can, within 7 days or 3 days if it's graffiti, submit a written demand for administrative hearing. And the way the code is currently written, those demands actually come to the court, although the court is not necessarily involved in the administrative hearing. So that that written demand says that they are requesting the hearing, so they would be getting that. There's a 2-day notice, a notice of a hearing at least 2 days before. But when they submit that, if for some reason they fail to request timely, so if they do it in 8 days or 4 days with graffiti or after that, that would be a waiver of that administrative hearing. Or if they fail to appear, so if they get that notice of hearing at least 2 days before the hearing, so basically 5 days of asking for their request, they would get that hearing. If they failed to appear on the date and time that it was assigned, they would also then waive that administrative hearing. So they've requested their administrative hearing, they got their notice at least 2 days before that hearing, then there's the administrative hearing. That administrative hearing is conducted by a hearing officer, which is designated by the city manager. And the sole issue of that hearing is just to determine if there is a nuisance or not. It doesn't determine any other factors, just whether there were weeds that weren't cut down or there weren't. And so if it is yes, if it is determined that yes, in fact, there were weeds that were not cut down, the order nuisance is abated, and then an abatement lien is possible, or the grass will be cut and they will be sent a bill. If it is no, the hearing officer would then vacate the notice and say, I'm sorry, code, that was a mistake, and they did cut down the weeds, or they didn't, or whatever that may be. So, and in the administrative hearing, they're very informal. There's usually very few attorneys. A lot of times it's code and the pro se defendant. And they talk about that. They don't have the rules of evidence in play, so they can just talk freely about what they think happened, or have other people come and say, hey, yeah, the weeds were a little high, but they weren't bothering us, or they didn't seem to be, or, oh my gosh, they were so high and somebody needed to do something because my toddler got lost in there and we couldn't find
Is this
them.
the point where the defendant brings in evidence and things like that
They
to
can.
show, hey, here's a picture of what it looked like on this day, yada,
Yes.
yada, kind of thing? Okay.
Definitely. And so yes, that responsible party presents that evidence, the pictures or testimony, public and city, meaning the code. Sometimes it depends on how the city attorney's office is set up at different times. There have been periods in which the city attorney does appear with code at these hearings. There are other times when city attorneys do not feel that that is the case, and the code represents themselves as the city, and then the defendant is solo. So it kind of fluctuates with the processes of the city attorney's office. But they also, the city would be there as code enforcement and present their information, what they saw, the pictures they took, and all of the information in their report. The hearing officer hears all of that and makes the determination as to whether the abatement or whether there was a nuisance or not. And then they must give that written decision that same day. They do not get to dilly-dally. They must give that written decision that day. A copy is then provided to the party and to code that day. Usually it's emailed out to both parties simultaneously. That decision is final. An administrative process is final. Well, I say it's considered final. It can be appealed to a court of competent jurisdiction, but generally for an administrative hearing, the only thing that can be appealed is if there was anything done egregiously. So if for some reason the hearing officer, it can be shown that regardless of the outcome, they were biased in one way or the other, and that determined their outcome, that's what can be appealed through the court of competent jurisdiction. Yes, ma'am.
I've heard a report from someone, whether it's true or not, I don't know that, but that they had an administrative hearing and they were not allowed to enter evidence. And to defend them, I think it was a dead tree, and the person was saying the dead tree isn't on my property, and had evidence apparently from the county showing the property lines, and they weren't allowed to enter that into evidence. Is that appealable?
That would be an error in the process, because both sides are allowed to present the evidence that they have. And then again, it's very informal. They don't have to meet the legal, in a trial, you would have to meet the foundation. So you would have to lay a foundation in order to admit your evidence. So for instance, if you were trying to do your record, your county records, that's a business rule or records. And so you would have to outline, that's your rationale for, and your foundation for doing the evidence. In these administrative hearings, that is not the case. They don't have to have all that foundation. They can just say, well, here's my information. I have information that shows that the property line is here and my house, or my tree is here, the tree was here, or it was right in the middle, so we're both responsible, whatever that may be. They should be able to do that. And to my understanding, yes, they could appeal that ruling if they felt there was some procedural inappropriateness or mistake.
Do we notify people that are in administrative hearing that they have the right to appeal this, or not necessarily?
So it's a contractor that's been hired by city manager's office that does the appeals. So it's another separation of power. So it's honestly, it's a hit or miss every time we get a new person, a hearing officer. It is in code that they do have the right to appeal. So it is their right. I think if they would ask that they would know. I know one of the last appeals we did, it was explaining to the hearing officer of what their bounds were, that the appeal or that the administrative appeal process is basically on the date and time that the posting notice was issued. It's their job to determine if the violation on the posting notice was present at the date and time on the posting notice. That's all that the administrative appeal process is for. That's all that they're determining. So in your case, if their evidence is that, well, I'm not disagreeing that this tree was in violation at this date and time. My disagreement is that the address on that posting is not correct because it was a neighbor's tree. Then that would be something they could appeal to. In this case, Wood Arapahoe County would be the competent court for them to basically overturn.
Okay, and then on the chart where if they fail to respond to in 7 days or 3 days, like she said, 8 days, and it's waived, does that mean they just go straight to penalty?
And that the city doesn't have any further hurdles before they can initiate the administrative abatement on that side of the administrative process. And I think, the appeals would probably, go to 18th Judicial District Court, is my understanding. And I'm trying not to be offended by the interpretation of competent jurisdiction. While I feel I'm both competent and have some form of jurisdiction, I think what they also really mean is a court of general jurisdiction. You know what I mean? Because our court is a limited jurisdiction, municipal court or municipal code violations and municipal charter violations only. And this is a little bit outside of that. And I think also the desire to have somebody outside the City of Inglewood organizational structure review that. And whether or not it's de novo or abuse of discretion standard is unclear to me, candidly. Whether
I think it depends on what you were arguing, because in your situation, it may be abuse of discretion if they didn't allow them to submit evidence. But if it was just based on the basis of the ruling itself, then yes, probably de novo. So it probably would just depend on the circumstance.
And appeals come in generally two flavors. One is de novo, where essentially the judge is retrying the case, essentially, versus abuse of discretion. Did the previous fact finder or the previous judge make an error that I can correct? And if not, then I won't touch it. You know what I mean? And so those are two different standards of review in an appeal process generally. And I feel like our code's a little bit silent on that. So the infinite wisdom of the district court judge will settle that, I'm sure.
The hearing officer, I'm kind of interested with this person, gets hired, I sense, by the city's manager. And I think, Rita, you mentioned something about, does it get passed by council or by council as far as?
Generally, sometimes the hearing officers for certain things come before council, that the city would use those hearing officers for different things. I'm not sure that these hearing officers, are these appointed by
They are on the
council?
list. They're on, yeah.
Okay.
The council has a resolution of a list of persons
Okay.
that can be utilized for the hearing officers. And then when the city manager's office is called to get one of them or hire one of them, they go through that list and then.
I will say though, now we've opened the language of the code, so any attorney can be the hearing officer without being on the list as well. But I think that the city made some effort because there's sort of natural ebbs and flows of these types of issues, right? And we had sort of a natural uptick. And so the city attorney's office made some effort to say, here's who we call in these instances and put together a little bit of a roster. But the reality is they could call somebody else.
Is there an accountability to those people, I guess is where I was going. If you get one of these people who perhaps doesn't understand the code well enough or understand the process of doing the appeal or whatever it is, who's ultimately responsible for holding that person accountable for what they're doing?
I guess I'd say, it's probably both, the appeal rights, you know what I mean, that, ensure that that person's individual case is handled appropriately. But what I think you're talking about is the management oversight of that, and that the city manager should probably choose wisely, right?
Well,
And
I
that,
assume so,
you know,
but you
when you
never know.
choose someone, that you take some responsibility for that, right? In my opinion, right? Just like when I appoint an associate judge to one of our cases, I, you know, take some level of responsibility for that. Obviously, I'm not the judge that day, but I need to ensure that that person's licensed and competent and generally capable of handling these matters in our court. I'm limited somewhat because I must have a resident and a licensed attorney who's also a registered voter here. And so I've got even more hurdles to try to get that right person. And then ultimately council will also appoint that person to our bench. And this process is a little less formal than a judiciary appointment into these hearing officers, and only recently has been formalized to this level of this resolution in the last few years. And probably could use some additions, as my guess, as far as, you know, having more people as backups, and so that those people are more known to the person making those appointments, right? Oh, yeah, I have some history with, you know, Mr. Smith or whoever it might be, or Miss Smith, so that they can make some reasonable decisions about who to appoint for different types of hearings. This is only one flavor of a type of administrative hearing that these types of hearing officers hear in an administrative hearing. And so, you know, maybe in the future there might be somebody who's, and I think that the resolution does this. It says this person's general municipal, this person's sales tax, this person's, you know, sales licensing, you know, each different categorization. I can't remember the resolution right in front of me.
I guess before it were to get to a punitive state with a hearing officer who may have not understood, or I think the word interpretation was used, what is the process like? Where would we understand where they were onboarded, right? Like, how do we understand that they were trained properly to actually, especially for something like this that feels so linear in terms of how it is laid out and how evidence or no evidence, evidence, yes, foundational, no, not needed, right? It's very clear. So I'm not sure why it would be interpreted based on who happened to be the hearing officer at the time. And so some of that to me is not necessarily at the end of the process, but in the beginning of the process, not even just who you're hiring, but what are they instructed and how are they instructed, and where do we understand or see that?
And that's a good question. I don't know that there has been, and that may be something AJ and I can converse about and maybe get with the city attorney and talk through some of that, because I don't know that there is, I'm going to use SOP as standard operating procedure for those hearing officers, but you bringing that up is a really great idea. So there would be that consistency for all of that, because again, they vary, right? It's who happens to be available on that date, because again, it's a very short time frame that they have to do it, and that's why they have a list, and it's who's available really. And so, but that may be something that the city attorney may be interested in, to say, hey, here's a regular outline of what needs to be done, and remind them, rather than each hearing officer having to go through, read the code and re-educate themselves every single time. So I think that's a great idea.
Perhaps as part of an onboarding process, you know, it's a delicate balancing act. You know, once the officer is appointed, the idea is that they're an independent hearing officer who's capable of ruling against the city who just retained them, right? And so it's a little bit of a balancing act, but I do agree that at the point of their appointment by the city council would be a great opportunity before we got any live conflicts to do some onboarding. But that's certainly outside of the purview of our court as a third branch.
I've got a question, a concern, actually. Reading what you were talking about and then what you said about the person understanding their rights to appeal and on what basis. Do we really give the citizen the information to know what they can appeal, who they can appeal to in the period of time? Do we give them something concise that a normal person can understand, not in legalese, but in something that they can understand? Do we give them something in writing or provide them with that?
So the initial, their right to appeal the initial posting notice, the 7-day requirement, that is on every notice that's issued.
Okay, they have the right to appeal.
Right.
But do you explain how, not just contact so-and-so, but what the appeal process is, and then if they disagree with that appeal process, like this guy not getting his information, his evidence provided, do they have something in writing that they can look at and say, okay, this is a standard, this is what I've got to meet, and this is what should happen? Do we give them anything like that?
And I'll defer
I want
to
the citizen to
court for just a
understand.
regular appeal process in any.
Yeah, generally, that would be the duty of the hearing officer in my mind. Obviously, that's also the purpose of the code, right? Publicly available law that everybody can try to understand and has a fair ability and access to, right? And it's available publicly online as well as through our city clerk's office. But I can't speak directly to how folks are advised on the right to appeal of the administrative hearing officer's decision. I agree with AJ that the notice form very clearly indicates their right to an administrative hearing. I'm not so sure how the appeal rights of that administrative hearing officer are then communicated in that hearing or post that hearing. And generally, in our court, generally we give general advisements in our court on any criminal case. They have 35 days to appeal any decision of our court or any sentencing of our court up to the district court as well. And so we generally give that advisement to all folks in our court. But exactly what those timelines are and how that advisement's done from the hearing officer is unclear to me.
Yeah, and this seems kind of unclear to me. I'm uncomfortable with that for a person going in, not knowing anything. When you go to court, usually you talk to an attorney or have more things going on. Going to a hearing officer, I don't think people understand that. I wouldn't have understood parts of it probably, so.
If I could add to that, similar to Linda's question, I look at this, and then I listen to the conversation and the explanation. There's a lot to this. If this, then that, if this, then that. My question is, if I'm that person with the tree dispute, and I'm just entering into the process, I'm curious about dates and deadlines. Do I get a picture like this? You know what I'm saying? What's fair to that person is because if I understood the process, I might say, I'm just gonna surrender. I can see where I stand. It's not worth the argument. But there's a lot here. I mean, this is complicated. And I don't know that it's an easy answer. So I'm not, but along with Linda, I'm saying is there a preview or is there an overview that I would get? I'm that citizen who probably needs to go to a hearing. It'd be nice if I had, I guess, something along the lines of this with some explanation to it.
I think the notice of violation itself tells you have 7 days to respond. Is that correct?
Right.
And
Yeah,
it might point you to the code, but it's not gonna outline it like this, right? And this is my effort to try to say, hey, rather than us looking at the block of words, you know what I mean? Let's look at this. And, ultimately, this work product could be your work product, and you guys might use it for future notices or future communications with the public to help them understand. Because, ultimately, what you guys are raising is a fundamental fairness issue, right? And understanding the process before you begin is really fundamental. And we take painstaking efforts in criminal cases to make sure everybody's aware of what all of their rights are before we even accept a guilty plea or before we begin that process. And so I think that, these are reasonable questions to be thinking about as, trying to improve the process.
That might be something we want to look at in the future, because this is aside from what you come in to do, which is
Yes.
basically walk us through the criminal or the court.
Great segue.
Yeah.
And that is,
one
please,
thing
AJ.
to build on that, one thing we do want to be careful, because I know we've gone down this road before, and it's been advised against. I know we have 2 attorneys down there, but we don't want to be going down that path to be giving the legal advice. People go to law school to become attorneys, to know those processes. So once they do go to those hearings for appeals, that's where attorneys who have gone to school, who know that process, who if they're appealing to district court or they're appealing to the 18th, if that's something where, people call up to us all the time and they're looking for that legal advice. Hey, I'm having this issue. That there is a point that regardless, even the court will do that to where if they want to represent themselves in the court, and I've heard the judge do that as well, is that I can help you so far, but you need to seek legal advice. I can't give you legal advice past a certain point because that you need to do that yourself. We can't be giving you that legal advice. So that if there's guidance or if there's a standard form that we want to do for procedure that's in code for timelines, I think that's okay. But I don't think we need to be creating items that are providing them that legal advice for moving too far, because I know
Right.
we've done that in the past and talked about with different committees, and that's led down a lot of extra work that ended up going nowhere, so.
Well,
Yeah,
I think you're right. I think what we're looking at is what I'm hearing from you, Linda, is that people need a kind of a roadmap. They need to
Yeah.
know what's coming down, what kind of options they have at this point. You know, I think it's, a spreadsheet,
Might be
some
this.
kind of, yeah.
This
it's
isn't
just a-
something that you hire an attorney for normally.
Right, it's just knowing the
So
path.
it's understanding the
Yeah.
process, I think is really critical for the people, because the average purchaser is gonna know that. Give them the basics of what they're looking at, what their rights are. I think that would be very good for the citizens.
And I think that's something we can probably address later.
Yeah.
And part of it is the nature of our criminal justice system in the United States is, by definition, adversarial. And there's some pluses and minuses to that, and maybe we're raising one of the minuses, right? But that doesn't mean that we can't provide assistance to those pro se folks, but sometimes those can be very costly, right? In our adversarial system, it'd be best if the city hired a lawyer for all these pro se folks, right? Oh, they know everything and they'd have perfect representation, but at what cost, right? And so I think that there's some balancing act there as far as, what can be provided to keep the playing field level, and so that pro se defendants feel like they got a fair shake, or at least advised on the front end, and they can say, oh, I'm up to this task and I can handle this on my own and represent my own interest, or boy, I better go hire a lawyer because this is, flying over my head, right, before the hearing begins.
I'm not gonna hire a lawyer for weeds, but I'm gonna rights.
All the weeds, right?
Depends on what level of nuisance and what, charges we have
Yeah,
perhaps.
If I was doing that,
$3.50 an hour.
And so moving on to the court process, when we get to that box, and again, we highlight that, just looking at that 2024 report, I think it said there were 200 some odd cases that made it this far in the summons and complaint out of, I can't remember how many thousands of cases were included in all of that activity report. And so again, this is after, code enforcement has made some efforts to communicate and all of that, right? But begin, on the top left there with the summons and complaint, which is a fancy word for a ticket, right? A ticket gets filed with our court and served on the defendant. We do have cases that are initiated through arrest, but very rare on code-related issues. Those are mostly reserved for more serious criminal actions. But the code does have some authority to arrest on some of these issues. But normally, these cases, 99.9% of our cases begin with a ticket filing. And they are set for an initial appearance, either through the Violations Bureau or a formal arraignment or reading of the charges in open court, along with an advisement from the court more directly. Though that's another area of officer discretion, whether or not to write certain types of offenses into Violations Bureau, and the Violations Bureau has its own fee schedule for things like dog off leash, tag and collar violations, rabies vaccination violations, these types of things. Certainly not an animal attack, right, where we've got to deal with more substantive issues in the case. But there is some process there for an expedited process at our Violations Bureau front counter, whereby the defendant is generally advised on the ticket, please come to the court front counter no sooner than 7 days, because we need some time to get into the system. And hopefully in the future, maybe we can beat that down. We do have folks show up that day or the next day. I just got a ticket. I'm ready to resolve this. And we got to say, hey, hold on. We got to play catch up and call a code or something, get a copy of it. But no sooner than 7 days and no more than 30 days, come to our front counter. We'll advise them of generally their rights. And if they would like to, they can simply pay a fine on the fine schedule and end the case right there at the front counter. If they choose not to admit guilt on the matter, they have the right to enter a not guilty plea at the front counter and set the case for a hearing in front of the judge, or ultimately a trial on that matter. The second option or path from the officer's perspective is just to set them for an initial formal arraignment with our court. Those arraignments are generally done on Wednesday mornings, and there's a relatively large room or courtroom. We play maybe about a 6-minute video advisement of their rights. If you guys are so interested, that's available on our website. You can put yourself in the shoes of a constituent who's facing a charge in our court and watch that video advisement and decide for yourself, hey, does this adequately describe the process and my rights? And can I understand that and make some affirmative decisions for myself? Generally, after there's a reading of the charges and an advisement of rights, the defendant has an opportunity in open court on that day to either enter a guilty or a not guilty plea. If they enter a guilty plea, we skip to this bottom box to sentencing. If they enter a not guilty plea, that essentially preserves their rights and sets their case for the next step in the process that we call a pretrial conference. The pretrial conference comes in two flavors, jury trial pretrial conference and a court pretrial conference, just indicating which path we're sort of heading down. Almost every offense in Inglewood is jury trial eligible. Both because of the possibility of a potential jail sentence due to the general penalty provision I described, as well as the standard of the conviction of the criminal offense. Almost every offense is jury trial eligible. Very few proceed to the final box, however. I would say, certainly way less than 1% of our cases result in a trial, and even less of those result in a full-blown jury trial. A jury trial in our court is heard by 6 residents of the city of Inglewood. And in order to be convicted beyond a reasonable doubt, which is the higher standard of proof in the legal system, it requires a conviction by all 6 of those jurors of your peers. In the state system, generally they use 12 jurors, right? So a little bit simplified process for jury trials here. Has anybody ever been summoned for a jury trial in Inglewood?
Not in Inglewood.
You have?
Years ago,
Okay.
not recently.
Did you serve on the jury or not? With
I
Vince?
did.
Yeah, okay. Sure.
I don't even remember, it might have been before Vince was here.
Oh, really?
Yeah.
Lou Gresh?
I don't remember.
And at each stage, right, we have an opportunity going down to this bottom box where the city can decide, you know what, we messed up, we agree with the defendant, we're ready to dismiss this case. And that happens, both for, some discretion of the prosecutor. The second level of discretion of the government is through the attorney in the courtroom. And the attorney in the courtroom has the discretion to request that the judge dismiss the case if they feel like that's in the best interest of justice. Maybe it's because they don't feel like they can prove the case beyond a reasonable doubt. Maybe it's because the defendant has cleaned up their issues and has tried to resolve those and they feel like they need a break, something in that range. Acquittal is describing when you take the case to a trial and you're found not guilty by a jury of your peers, or you're found not guilty by the court itself, by the judge. And then finally, sentencing. And before I get to that, I'll cover this left bottom box, right? And that is, if anybody fails to appear for a properly ordered court date that's properly served on the defendant, we really only have one choice, and that is to issue a warrant for their arrest. In certain instances, especially regarding code-related issues, some municipalities have chose to both decriminalize and add a default procedure if the community feels like a bench warrant's not appropriate. But in our system, in Inglewood, we've not decriminalized nearly any offense that's not a mandatory decriminalization, like a parking ticket or a minor traffic infraction. The only examples I can really think of substantial decriminalization are what's happening at the Violations Bureau, as well as snow and ice. I think this body actually looked at that some years ago and defined the penalty range. And so snow and ice has got its own unique penalty provision, unlike almost every other offense in Inglewood. And whether or not that's appropriate, is, I think, a decision for you guys and for the council ultimately to decide. But when somebody fails to appear for a properly ordered court date, as the judge, I have one choice, and that is, do I want to issue a bench warrant or not, and what flavor should it come in? And ours come in multiple different flavors, both from the how quickly it gets issued and what the appropriate bail amount is. So first and foremost, we decide, and we have an FTA docket, a failure to appear docket every day, whereby the prosecutor and I will call each case on the record. And of course, this is open to the public as well. And we try to decide, is there such an eminent public safety issue in this case that we must issue an immediate bench warrant for this person's arrest? This is the assault cases. This is the domestic violence cases. This is relatively rare for most of our cases. More commonly, we issue them with what we call a 48-hour automatic stay. And that means that the bench warrant that's ordered by the court will be issued after a 48-hour period if the defendant didn't come to court and say, hey, I messed up, I know I missed my court date, how can I get back on track? And that is probably the majority of the bench warrants we issue. However, more common in code-related cases is a bench warrant with notice. If we know where this person is and the public safety issues are not that imminent, we will send them a letter saying, hey, you missed court, and giving them at minimum 1 week to contact the court and reset their court date before a bench warrant's issued. And so we have those 3 different levels. And this is one of the reforms that I've added, honestly, as our presiding judge, just to try to right-size these solutions before taking the ultimate step of taking someone's liberty, right? Because that is the ultimate taking of somebody's liberty, of putting them in custody and in a cage. And, we try to reserve that wherever possible. And the bond is also, or the bail of the bond is actually individualized in each and every case. So we call the case on the record. Sonia Strom missed court today, and it's her only first time missing court. And Judge, I think we should send her a notice, and I think we should grant her a personal recognizance bond, which means at that time when an officer sees them, they can simply reset them either on the side of the road or at the police station, or I guess potentially at maximum get booked into the county jail, but then immediately released on a promise to appear, which is essentially what a personal recognizance bond is. You don't need to post any amount of monies or surety. You sign a document promising to appear. Personal recognizance bonds sometimes come with a dollar amount, and that's the potential amount that could be imposed if you violate the conditions of the bond. The bonds can also have other non-monetary conditions, like stay away from the Safeway here in Inglewood or something like that, or that could be considered a violation of your bond, and the judge could revoke your bond and put you back into custody. But generally, we issue personal recognizance bonds, or we choose to issue a cash-only bond or a cash or surety bond. A cash-only bond is whereby you must pay that amount to the appropriate body, whether that's the sheriff at the jail, or whether that's our front counter clerk, or whether that's over at the Inglewood Police Department. You need to post $50, or you must post $100, for example. Cash or surety is using a professional bail bondsman, or could be using a professional bail bondsman, who might only charge you a small percentage of that amount in order to post the bond on your behalf, usually 10 to 15% of the bond. We generally don't use these types of bonds unless it's a more serious criminal offense, whereby we think we could be aided by the bail bondsman finding the defendant for us if they end up absconding on their court date and on the criminal charge. So it's pretty rare on a code-related case where there would be a substantial cash or surety bail. More often it's personal recognizance or a small cash bail.
Joe, can you help me understand what kind of cases get to you? What do you see? What sifts up from code enforcement, I guess, more importantly, is,
From code, I think the most common probably categories of cases include nuisance and animals. And so honestly, I think, you guys talking about Title 15 makes a lot of sense to me, because I think that represents the majority volume of the cases that we hear from code enforcement specifically. Secondarily, probably, in the past, it was animals leading the way, but also seen some reduction in filings of animal-related cases, unless it's like more animal-related, attack or something in that range, whereby there's a victim in the case. And so it's a lot of dog and a lot of nuisance-related cases. Trying to think of what might be a distant third. AJ, what do you think?
Probably more of our park violations.
Yeah, general rules violations, park rules violations. Are pretty common, sort of catch-all, and, we do see a fair amount of those from parks enforcements.
are these people saying, I didn't do it? I mean, is that how they're getting that far into the
No,
process?
very rarely. I'm describing the whole full-blown possibility of options, but, keep in mind at each stage of these boxes, we're, disposing 90% of them at the original appearance, right? Most people are taking initial responsibility, I would say. However, we do have some folks, a smaller percentage of folks who say, I'm not guilty, or there's some mitigating circumstances in the case. Most commonly, those involve mental health, substance abuse, and poverty, candidly. And so they want to, try to structure something with the city as part of their guilty plea in order to be reassured that they'll be given some reasonable timeline to take care of it and those types of things. And so they'll usually 90% of them will do it at the first, court date of that arraignment or at the violations bureau. Maybe the other 9% will do it at a pretrial conference after meeting with the city prosecutor one-on-one privately before they come into court. And most of those people come in to court with the prosecutor saying, "Judge, we solved all the problems, here they are." And will enumerate a plea agreement with the defendant whereby it calls for very specific court orders. You must clean up your property within a certain number of days. You must comply with the England Municipal Code. We're going to put you on probation for 6 months. Some of those types of conditions are pretty common. And so, sorry, I think that segues to my sentencing box on the right, but I did want to highlight that there has been some reform in the state of Colorado on arrests, and at the very bottom left of that box, it just kind of highlights that if a defendant can't post bond, there's an automatic personal recognizance bond process for charges with no state equivalent, which is pretty much every code case, unless it's dangerous dog is the one that kind of sticks out to my mind, whereby somebody could be held in custody if it were a serious enough case. But normally, if the court sets a cash or surety bail and the defendant can't post it after being in jail for some period, 48 hours maximum, they'll be released by the sheriff's authority on a personal recognizance bond with a new date with our court as part of that reform. And of course, anybody who gets in front of the judge on those types of charges must be granted personal recognizance by our judge and by our court. And that's part of the newer reforms in the last couple of years, unless it's a state equivalent of a misdemeanor or higher. Sorry, I know that was a lot.
Oh, sorry. The dangerous dog part, didn't they change that to dangerous animal?
Yeah, there's a part in state, I have to go back and actually read it.
Yeah, I think he's referencing that, the city made some amendments to definitions of dangerous animals. And that probably needs a little bit more work because it says dangerous animals are defined as any dog or cat that does the following. And so that might be a cleanup issue.
I
think
they did.
there was some intent to broaden that a little bit, but in my mind, it still only applies to dog or cats. But, the reference of animals and domesticated animals also had a lot of other uses, like now the Code Enforcement Department is authorized to impound other animals besides dogs or cats. But, I know dangerous specifically is defined as any dog or cat that does the following.
For muni or state?
Well, I was thinking muni, but
Yeah.
just the fact that with the pets people have these days, dangerous
That's-
dog just seems to be, unless the court's taking that as an all-encompassing term.
No, there's
And-
very strict
and
definitions.
Somebody has a tiger.
No, that would be illegal in the
Well,
city of England
I'm,
and the state.
okay, a
There's
very large.
most
iguana-
Chicken that bites you,
But do you understand what you're saying? And
Yeah.
and that's,
Yes.
when you're reviewing that and looking at that, that's something to take into consideration.
Have dogs, cats, chickens, and.
Yeah, so there's dangerous
Goats
dog and
inside.
cat,
Well,
and then
but-
there's harboring a dangerous animal.
But
They're
people
two
have
separate
snakes and iguanas.
But I do think that there was some intent to broaden that definition, and I think there was a little bit of maybe an oversight of the definition, but I could be wrong. Maybe that was the exact specific intent, was to, define dangerous animals as dog or cat and leave some of those other definitions of animals more broad. But yeah, in my mind, when we convict somebody of dangerous animal, it must be a dog or a cat.
Yeah, so dangerous dog or cat, we don't deem it as a cat or dog that's dangerous, that's done by the court. So they're not automatically deemed as dangerous. Harboring a dangerous animal, there is a list of animals that are predetermined as dangerous, such as venomous snakes, tigers, that type of stuff are already predetermined as dangerous. So it's prohibited to harbor a dangerous animal versus to be found guilty of a dangerous dog or cat has to be done through the court.
But those are
But
two
that's-
separate criminal offenses that could be
But
filed.
right now it says dog, not dog and cat.
Yeah, and I probably could have said dog or cat, yeah, my bad, that was me,
Okay.
just using a little
Oh, I
bit
didn't know if it
shorthand
was
there.
like copied from something.
No, I just kind of made a little bit of a shorthand.
But it does
note
say
there.
only dog and cat, so if you had a
Okay.
dangerous bird, we couldn't do anything.
It'd be harboring, it wouldn't be charging.
Or some other, perhaps, there might be some other
Bad
nuisance
bunnies.
grounds there. And so, what does a typical sentence look like? And I referenced the general penalty provision in Title I, and I kind of cited there, but, most of these cases are a fine. And, if it's a step up from a straight fine, then it's usually a suspended fine or conditionally suspended fine on some conditions. And here are some of the more typical conditions stemming from our court on a unsupervised probationary case, and that is don't have any further violations of the law for up to 1 year, which is our jurisdictional limit, you must comply with the Inglewood Municipal Code or bring your property into compliance. It used to be, when I first started here, that we had a lot of review hearings, monthly, how are we doing on this cleanup? And the city's preference is to not have as many reviews, and so a lot of those are going through communications with code to give feedback to the court on those compliance issues. And if compliance is not done, generally it's taken up at the date in which the case is scheduled to end or by motion. So there are multiple ways on how to monitor compliance with those, but generally at sentencing, they're ordered to immediately comply with the code. Also, there may be some rehabilitative or restorative element to the sentence. Do some community service hours to try to make right for some wrong here in the community. Take this class to try to educate yourself on property management so you don't find yourself in this situation again. And we do have some providers who teach some good classes on that kind of stuff. And maybe you guys are interested in that. I can send that class over if you're interested. And then finally, the possibility of a judicial abatement. Post-conviction, the court could order the authority of the city to abate administratively post-conviction. So if they enter a guilty plea, the court has the authority to order a judicial abatement at that time. Candidly, the city does not request this very often. I'm not aware really of any judicial abatements as I've been the judge here in Inglewood.
Yeah, 2018, 2019 is the last one I think I can remember.
Yeah, okay.
That house.
And that would have been my time though, you know what I mean? I took over in January of 18, and so maybe it's so ancient history, I just don't recall, but certainly that's something, and maybe that's something we could start to exercise more if the city felt like it were appropriate relief. Again, a lot of times in these cases, even in the review hearing settings, it was a lot of, hey, Judge, this person's been trying, they're disabled, they have some poverty issues, they have other things. And so we were making fairly substantial efforts to connect them with friends or family who could help them with their property maintenance issues, faith-based organizations, neighbors, these types of things to try to problem solve on behalf of the community. But now a lot of that problem solving is happening outside of the courtroom because of some of the processes we described before the summons and complaint, as well as with the reduction in some of these review hearings, that's happening between the code and the prosecutor in a lot of these cases without me. Any questions on this slide? I know that was a lot, and I know that this may be the meat of some of the questions for me regarding sentencing or regarding how do we deal with folks who are not showing up to court or not ready to take responsibility. Rick?
Just a quick question on the paragraph under the sort of bail bond headline. You had mentioned that that's based on some reforms. So is that, and then a couple of things were suggested. So is that part of what we do now? Okay, great.
Yes.
It's not something we're looking to reform. Got it.
No,
Just wanted to clarify that.
Prior to this recent reform, our judge held discretion on every offense, right? And whether or not they needed to remain in custody on bond till they posted bond, or whether they should be granted personal recognizance. So the state has provided guidance to all municipalities. Initially, it was, for example, thefts under $50, right? And now the line has been moved to $300. And so if I see a theft for $299.99, I know I must PR that person under the law. If it's $300 or more, I know I have discretion based on their previous compliance with court orders, whether or not they failed to appear in the past, those types of issues. And so the state has sort of defined some category of offenses that they view as should be granted personal recognizance. And candidly, that pretty much covers every code-related offense besides dangerous animal, because that charge can lead to substantial serious bodily injury and substantial restitution issues that can be very criminal. I mean, an animal attack that results in death is a serious felony here in Colorado. And even ones that result in serious injury need to be taken pretty seriously.
And those personal recognizance, I can't talk, it's getting late. Those mandates were statewide too. So the state offenses have similar guidance. It's not just for the municipal courts.
Does the judicial abatement, I know it's very rare, but in a judicial abatement situation, the cost associated with that, is that similar to what's done currently with abatements whereby the city makes sure it's taken care of and then goes back to the county to, is that handled
It
that
can also
way?
be collected through the criminal case, right? So
Okay.
if I order a judicial abatement as part of their sentence, I can include the entire cost of that abatement. In order for them to successfully complete the case, they should pay that. That being said, another area of reform here in Colorado has been debtor prison reform. And the idea that a person shouldn't be jailed simply for inability to pay fines and costs of the government. That there needs to be some willful act and ability to pay, and hey, I'm not gonna pay even when I can. So more of like a contempt type standard on a money only issue, which is what even a judicial abatement would be considered. It would be a cost in the case. And of course, failure to comply with these court orders could result in imposition of either the conviction, additional fines, or possibility of a jail sentence if it was suspended at sentencing for public safety issues or egregious violations, right? So if we've got somebody who's really thumbing their nose at the court on certain issues, then the court has the ability to suspend a jail sentence or sentence them to a jail sentence upon conviction. But it is exceedingly rare on straight code matters, right? But even the threat of it, I think it, alleviates a lot of those concerns.
Our code version currently reads 3 or more notices of violation. Is there a period of time that those are received?
Yeah, I think you're talking about there's some sort of prima facie, kind of like, it's saying, hey, if you have these number, then, in court, the court can consider it not just a strict liability issue, but that you had some specific intent to violate the code, right? And that makes the prosecution go a little bit easier and also can be factored into sentencing. And so it's kind of almost like a habitual offender type of a concept there, right? Whereby, the standards of proof are a little bit relaxed if we've done this a few times from the government's perspective. Thanks. Other questions on this slide? The other areas of Title 15 that we're not going to dive too deep into in the best interest of our time, and I just wanted to make sure I enumerated all of these because again, these are what's enumerated in your guys' bylaws and in the local ordinances, and so I'm just trying to enumerate each of those. And that includes, of course, the cutting and removing of grass and weeds, which we know is, that 6-inch standard. Placement and removal of trash is pretty meaty. That just, describes both littering and, the requirement to have somebody come take your trash and the requirement that that person be licensed by the city and all of those types of standards of, how we're dealing with the placement and the removal of the trash on both private property as well as in the public right of way, right? What days, and times and how long can you leave it there after pickup? All those types of standards are all in that area of the code. Outdoor storage of personal property, defines, stuff like, hey, you can have furniture that's designed for outdoor use, but you can't have your regular couch out there, right? And so this defines, what is allowed to be stored outside and what is not allowed. And, also defines, whether it's publicly viewable or, screened from the public, these types of standards. Finally, I'll just highlight the vested rights and takings determination. And essentially that is above and beyond the administrative hearing that we just described. And essentially, if anyone claims that the enforcement of any portion of this Title 15 has interfered with their vested rights to develop, or who claim that their property has been taken by reason of abatement of a nuisance arising from his or her property, can request relief under this section of the code. And that process is very detailed and much more nuanced than the presentation we just made for a nuisance administrative hearing, if that makes sense. This is a much more involved process, but also involves the city manager designee hearing officer, some discussions, and opportunities for the city manager or their designee to come to some agreement on all of this before going to a determination by the hearing officer on whether or not what happened interfered with the rights and the property rights of the defendant. Any questions about those areas? And I know that you guys were kind of looking at
It's pretty
those.
meaty stuff that.
It's pretty meaty.
Oh, my gosh.
And so that's why,
Wade through
you know, I
that.
feel like if you guys have some plan of attack before you dive into too much of it, is what I'm trying to do, and roadmap some of it. And, you know, you guys can kind of pick your spots, you know, hey, maybe we're gonna discuss this one area, or we're gonna try to, you know, do it from 30,000 feet, because it's too much to kind of go into in one sitting, if that makes sense.
Is there anything you have concerns about in there? Is there anything that as you read through that you would say, hey, you know what, that's vague, or that's probably could be revisited?
Probably, you know, that emergency area kind of stuck out to me. I do know that some municipalities are struggling with this in the news, you know, on whether or not this rises to the level of an emergency abatement whereby the government can come onto the private property and do what it needs to do, you know, I've heard of some controversy around the state on these types of issues, particularly regarding homeless encampments and these types of activities, right? And so, you know, that might be an area that, you know, might be worth reviewing. But again, you know, I don't want to be too opinionated on all of this, because, you know, my job is really to imply and interpret what's here. And, you know, I try not to be overly opinionated on what I think the policy should be, but that's one area that kind of sticks out to me as just a little bit ambiguous as far as the procedures for that, because there really is no review of that emergency process, if that makes sense.
Thank you.
And so, you know, if we ever had a true villain who was operating as a city attorney's office or city manager's office, you know, that could be problematic for the citizens, right? But, you know, I haven't seen any problems with that, so please don't try to, you know, interpret that as me, you know, implying that something has happened, you know what I mean? Because I certainly am not aware of it.
We won't touch on it.
Thank you. You might have heard me.
You won't.
Okay, moving off of Title 15, here's some other areas that were enumerated in your bylaws and in the municipal code. And I'll spend just a minute, maybe or two, talking about what really dominates a lot of our docket and stuff is these animal-related issues under Title 7, Chapter 1. And we already talked about the dangerous dog or cat issue. But really, I think what I'm wanting to highlight there is fairly substantial changes to the impoundment process here in Inglewood. You know, just a couple of years ago, the city made modifications to 71A5, the impoundment of animals notice and disposition area. And really, you know, it is kind of a nuanced change, but really resulted in pretty substantial changes from our court's perspective. And that is the number of days in which somebody has the ability to claim ownership of their animal. Went from 6 to 5, I believe. And you know, while that might seem like a very tiny change, it resulted in a fairly substantial procedural change for us. And that is, prior to this change, when the city impounded an animal and cited them for the underlying offense, whether that was dangerous dog or dog off leash, they were set for an expedited hearing or an expedited arraignment outside of our normal timeline, the following Wednesday morning. And by having 6 days, we were able to always assure ourselves that nobody would ever have to show up to court in the morning, getting a late ticket, and they would always have an opportunity to be seen the following Wednesday. At that arraignment advisement, we went through this issue of whether or not you want to surrender your animal or whether you want to make a claim for your animal. And now that process is an administrative process that's totally separate from the court charge and process. The current arraignments are set out a few weeks, just like all of our other arraignments. And by the time they get to the arraignment in front of me, the issue regarding the claim of their dog is already gone, right? Because they've missed their notice period for requesting a hearing on that issue. And that can go pretty quickly, right? 5 days. And so don't get me wrong, I'm sure code makes efforts to notify them of where their dog is. And that's what the code determines. It says, you know, they must make reasonable efforts to find the owner and notify the owner and how they can pick up their dog over at the Humane Society. Generally, if it's an issue where the dog was just off leash, they can just come and prove that they're the owner, pay a shelter cost for the daily boarding rate or a flat fee that they've kind of moved to, or any other cost of care like a rabies vaccine or something in that range, and get their animal back. If the purpose of the impoundment was cruelty or neglect of the animal, dangerous animal, or rabies, then the court can generally conduct the hearing and decide whether or not that animal should be released back to the defendant. And so really, I'm just highlighting that, there was a, minor change in the code that resulted in a fairly major change in the in the arraignment procedures on these animal-related cases where the dog has been impounded.
Is that 5 days or 6 days? Is that working days, business days? Or is it just days?
Yeah, I think it just says 5 days,
Yeah, I think
and
it's-
that's under 71A5E. Yeah, makes claim of ownership within 5 days, and so I think we've interpreted that to be just 5 days.
So I guess what I'm hearing is this is making it harder on the owners to comply because of the way that routes into your week? Is that what I'm hearing?
I don't know that it's necessarily harder, it's just separated from the criminal process, right?
Okay.
And so that issue of claiming ownership of your dog could already be under the bridge by the time we're explaining the charge in open court to you on dog off leash or dangerous dog, right?
Okay.
AJ, anything to add to that? I feel like I kind of shot off the cuff there. I'm not sure if I spoke totally clearly on that.
Yeah, and that's something we can have a deeper dive. I mean, there's a whole bunch of, it follows state law, and state code of how the state does it. There's a reason
Correct.
to separate it. We were having dogs that were in custody for 6-8 months. There is a fee associated with it. I know the shelter got cheated out of several thousands of dollars in fees for dogs that they were taking care of. If the court process gets delayed from that initial arraignment date. So there's reasons for the separation, and if that's something that we want to talk about at a future meeting, because I know you guys are coming down to a timeline, we can explain the reasons why that was changed. But yeah, there is that timeline. I do believe we go based on business days to make sure we do meet that Wednesday hearing, so we're not expected to do like a random Tuesday date.
That would probably be one area to clarify, because it just
Yeah.
says 6 days,
Okay.
and so.
So even if it's issued on, so for example, if we issue it on a Wednesday, we are issuing that notice for that following Wednesday. We're given until that following Wednesday to submit the paperwork for that hearing. We're not cutting it off at Tuesday just to play that game. That's not any intention, because hearings are done on Wednesdays.
So clarification
so-
within the wording to say business days
So,
rather
Yes.
and even if we want to get rid of that wording or the following week's Wednesday court date or whatever, however we want to word it to make it even easier for the court to the following week's scheduled court date, or however we want to do it, to make it more clear, is easy as well.
I thought the state law was business days.
Yeah, and it could be, but they also operate 5 days a week for court hearings.
Yeah,
But with us doing it just on Wednesdays, if we want to tailor it to the following Wednesday court date, that's something that could be changed as well to make it clearer for the court, so.
So I appreciate that, and I apologize if that was a little confusing. I had some pretty structured stuff, and then all of a sudden I got a little off the cuff there, so I don't know if that was super clear, but that might be an area that might be worth spending some time on, and understanding some of those nuanced procedures and how people advise of their rights at each turn. Because unlike a lot of these other cases, when it involves a pet, people can get very emotionally attached. A lot of folks view these as their family member or something in that range, and I think Rita probably knows that, being on council for a while. We can talk about rapists or murderers in the community, and it doesn't get people as excited as we're talking about dogs off leash or something in that range, right? And so those can be very emotionally involved cases. In fact, I've probably only had less than 2 handfuls of cases since I've been the judge proceed to an appeal, a written appeal by the district court, and I would say probably half of those are animal-related cases, and that those can be a little bit more involved. Some other areas include, environmental pollution, graffiti, noise, snow and ice, tree management. I got graffiti twice? I guess I got graffiti twice. But those are other areas that are specifically enumerated in the bylaws and the municipal code. And with that, we'll stand for any final questions. thank you for your time. It really is nice to get out and see folks. I view this as an extension of our efforts to be a more community-based court and, you know, build upon some of the desires of our community to be the community court to resolve these cases. Any other questions or concerns?
Thank you.
Yeah,
Very much.
please let us know if we can be of further assistance. I appreciate all of your services on all of this. Enjoy the rest of your meeting.
Thank you so much.
Thank you.
Good to see you. Good to see you too.
Thank you for taking
the time out to do this.
Education, yes.
Yeah, thank you guys. Real pleasure.
I think let's move the code enforcement, the review of the monthly stats, code enforcement stats to the next meeting.
Yeah, and those are attached, so if you have any questions, we can.
Yeah, if everybody wants to.
Are these
review
different than
those.
what we got last time?
Yeah, so these are gonna be presented every month they're gonna be monthly updates, so if you have questions, they'll be attached to the
Cool.
agendas. The only thing I will, say for a change, it's not a change on reporting stats, it's just strictly a change in name. But you'll see moving forward, where it's currently says parks smoking, you're just gonna see it changes parks smoking marijuana or marijuana smoking. We're just identifying it that per city council's direction, we're no longer enforcing the no smoking at all in the parks. This is just delineate what we've been enforcing is basically illegal substance smoking. So marijuana or any illicit drugs is what we are enforcing. The cigarettes or vaping or whatever is legal that council's guided us that is legal in the parks. That is not included in any of our stats and hasn't been for a while. So just strictly a name change.
Just curious, why is marijuana illegal in the parks? I guess if cigarettes are legal, I'm just.
It's in the public.
Public.
So state law does not permit smoking of marijuana in the public.
And tell them on the 4th of July.
Well, I mean, you can drink beer in public.
Not the parks.
Have you been to the
What have you
4th,
been
have
doing,
you been to the
Bob?
4th of July
I have, and
at the park?
I've asked a lot of people to put it
Yeah, it
back
looks
in
like
their
a
car.
420 event.
Ooh, I have. I'm getting red-eyed just thinking about it. Okay.
You came in red-eyed.
I did, didn't I? Just kidding. Rita.
Actually, the judge shared something that I was gonna share anyway. The city attorney has been doing an ongoing comprehensive review of Muni Code. And on Monday night, of course, all of these, 2 or 3 of these got tabled, because not everybody was there, but also, the very 9A1 is CB 18, Municipal Code Cleanup Project, Title II, Boards and Commissions. And I would encourage you to go on to the agenda and look up 9A1 about the rewrite of boards and commissions. And just read that section, and I would like feedback from this board. Actually, I'm gonna suggest at our next meeting that we get feedback from all the boards about these changes, because sometimes it will impact some boards differently than other boards.
Some of them are being combined, right? Was there an effort to streamline some of these?
Well, more of it was to just clean up the code, and they will address things about appointing the chair and how long the chair position is. And I mean, I'm not sure that any of these things specifically address this board, but I think you should look at it because, and they're general things. The Water and Sewer Board is a 6-year term. And so wanting them to replace the chairman every 2 years in some ways doesn't make sense. And that we had that discussion in that board last Tuesday before the council meeting, and I don't even think they knew that it was coming up. And it's kind of ad hoc. I think the chairman on that committee has been chairman for, well, probably 6 years, close to 6 years. And interesting, boards appointments are for, excuse me, I think I'm having allergy problems.
They're bad right now.
Huh?
They're bad right now with the wind and the weather.
Oh, yeah. So if you're on the water and sewer board for 3 terms, that's 18 years. That's a long time. Now, like this board, are the terms
that's like
2 years or 4 years?
2 with renewal, I think.
So, anyway, I would like you all to share on that one.
Right, 2 years.
And actually call me if you have any issues, or email me.
So the council has not really addressed it, has tabled it at this point, so you
No,
want some.
they're tabled till the next meeting, mostly because there were 2 council members missing.
Okay, so you want us to take a look at it, give you our take on.
If there's something that's troubling to you, just email me in.
So they're gonna be discussing it at the next meeting, you said?
Yes, which the next meeting will be April 7th, I think.
And Rita, I didn't hear you said section 9A or something?
9A1.
981.
9A.
9A1, okay. Thank you.
And I will tell you that next Monday is a study session, and the council will be bringing up ranked choice voting or runoff elections for the mayoral position only. And so I would just encourage you all either to come or to watch it online. I don't know where it's going to go. Personally, I think 83% of the citizens in Inglewood voted to have the mayor elected according to our current standards. And when you got that big of a mandate, I don't think council should mess with it, but that's my opinion.
I agree with you.
And other than that, I don't think I have any updates unless you all have any questions.
Any discussion coming up on the motorcycles and noise, traffic noise?
I need to
We're
write
getting
that.
into that season already.
You know, I heard them the other day.
Oh, yeah, I hear them every day.
It's also cars. I mean,
Oh, it's nothing like these
Pocket.
dirt
I-
bikes that go down the street with no license plates and.
And I also add to that, cars without mufflers.
Yeah,
or
yeah,
mechanisms.
there's
So
some of those.
it's
They add
street
extra
noise
devices
in general, so
on it to make them even louder.
Oh, yeah, they do it on purpose.
Yeah.
Yeah.
Is drag racing still a problem?
I haven't heard them recently.
That's
It's
coming
a
though.
little bit early
Right.
yet.
That's coming.
Oh, yeah.
Well, they've been enforcing, and I think there were a couple times that one time they called in Denver to back them up, and I think the other time they called in Littleton.
Well, they do it there on Santa Fe, between the two, so.
You do it down.
Then last year they were doing Broadway, big
Really?
time, the motorcycles. I was out on an errand and I saw this group of motorcycles. There's 25, 30 of them.
I hear about Santa Fe all the time.
And that's legal now?
No.
There's,
No.
so it's
It's
enforced.
just, yeah.
I won't bring that up.
All right, next up is Communications Subcommittee.
As far as I know, we have not been approached by communications for any additional information. If we do, we'll let you know. Cool. I think we're kind of in that cycle stage right now.
Good. So you should start planning for snow for next year.
We're working, yeah.
Is there any new business?
Anyone have any questions from the judge's presentation, follow up, anything?
I would say we did not truly finish the review that we were planning to do. I think that he certainly they gave a lot of information. But I do think we probably need to have that to finalize the rest of that section.
It didn't look like, I looked at the agenda from last week. Did you do any last week or last month?
I mentioned the table that.
So, yeah.
Yeah, I'll just keep the muni review on there so we read through it.
So that's it for new business. Committee members' choice, member Hart.
I did not have time to go in and get more information. I've been down at the Capitol.
Okay.
Not ready for
I
that.
have something I'd like to bring up. It's open for me. I told you I had something.
I thought it was a golf outing. Oh, you said we were going to play golf?
That was kind of a lure.
Oh, man.
Take that.
Thank you.
Thank you. I want to just mention something, and I've been kind of working on this for a month or so. I'm going to take one of those and just pass them on around. I had approached AJ at the end of last meeting about something and kind of followed up. Did you need more? There's another copy. Okay.
I think you're ready to go.
What this is it's actually something which is more directed toward what's going on our sustainability committee, but I think it's definitely applies to what we do in this committee. In a nutshell, and you can read this kind of at your leisure, in a nutshell, I'm working to create some kind of certification program for residents who are planning to or in the process of or have existing native grasses in their yards that they are intending to as native grasses, as well as pollinator gardens. Michael and I have had some discussions about this. Right now, this committee, not this committee, but code is challenged by needing to educate themselves well enough to understand what a pollinator garden is, what native grasses are, what Coloradoscaping is. And what I would like to see is that a certification program to be developed whereby a yard goes through a process that is reviewed by a group specifically assigned to do that, to be able to qualify as a native, whatever we want to call it, a green yard. But some way of designating that so that it helps them to understand the responsibility you have associated with that, because there is responsibility associated with native grasses. You can't, they're not weed immune. You're still going to have invasive weeds in them. So the responsibility then is to maintain and take care of those weeds just like it would be in any other grass. But that comes through certification. It would happen probably through some subcommittee such as of the sustainability committee to identify that. They would be given that certification by having some sort of sign in their yard, some sort of plaque in their yard that recognizes that certification. The beauty of this is that it helps code enforcement officers to be able to look at that and say that has a certification sign in the yard, and therefore we don't need to try to discern whether this is native grasses or just somebody who didn't take care of their yard. And I know I had a discussion with AJ and with Dave. I think we got what I felt was positive responses from both of you about this idea. I took it to sustainability last week. Sustainability likes the idea. This would be a lead that would be taken with sustainability. But I want you to all to know about it because I think that this would ultimately be a sort of a cross committee kind of thing. I would bring to you what we're planning on doing and ask for your critical evaluation of what it is. Are we missing anything? Is this something which helps everybody, or is it something which makes things more difficult perhaps for code or whatever it is? But I would just wanted you to be aware of this is in process. Are there any questions that I can answer right now?
Our neighbors with Dana, so I know.
Oh, you know.
And our neighbors with Cara, so I know.
You know already about it.
So are you looking for us to do anything, for the committee to do anything?
I would like the committee's view from the code enforcement perspective on what the sustainability eventually comes up with. Look for problems with it, look for possible things that need to be reworded or refined in order for it to be more effective.
My only question would be, is there a cost involved? I mean, I think
There could be.
that's going to be where the city council is going to come in from. I'm just guessing.
Well, there could be costs associated with it. We talked about some kind of initial fee, mostly as a buy-in. And I talked yesterday with Sean about it. Sean liked the idea too, and he said, you know, the idea of a buy-in at the beginning commits people to doing it. It's like any time you put a little money out, you actually feel that it's a responsible thing. We're also looking at possible funding options to be able to support this also. What we'd like to have is somebody who is retained as an expert on these kinds of things, so that if somebody wants to do it, we can say, Dana, here's Dana's name. We're providing her some kind of residual, some kind of so that she can be able to advise you on it. And we're still looking at the funding right now for that. We're possibly tying that back in with the water department, because this would be an ideal thing as a feather in their cap for reducing water usage by encouraging these people, these homeowners. So that's kind of where it's at. Yes,
I will just tell you, I shared with the people at the water department this thing years ago, probably back in the 80s. I want to say there was water rationing to save water. And so what happened is everybody did such a great job in conserving water that the water department didn't have enough money to pay their bills. So they had to raise the rates for the amount of water we were using for less water. So there are always those.
So too good of unintended consequences.
Right. Well, and I think people do tend to conserve water. And as much as the water bills have been going up, I think we're going to see people conserving water a lot more.
And as you chip away at people who don't have meters, and as more and more people have water meters, that also contributes. Because we got a report a couple years ago on sustainability, and oh my Lord, the critical few, the most water usage, let's say residential water usage, was clearly attributed to that small percentage of people that did not have water meters. So that's the neighbor that's watering the sidewalk for 2 hours every night. And then the neighbor beside him is putting timers on their drip irrigation. So my understanding is slowly but surely the city is working towards someday everybody will be on a water meter. But it's
Yes, and I think that day is probably coming sooner rather than later.
Much.
I think part of it could be within 3 years, maybe.
There's costs associated with it. And I think that's been an impediment, is figuring out how, because people are on limited incomes and are being asked, because they're the people that have been in those houses for 40 years. So they're having to fork up $2,500 or whatever for a water meter.
What has been happening now, the meter replacement, that has been substantially reduced. I mean, I knew somebody a couple of years ago that paid $1,100 to have a meter, but now they've changed it to $300, and I think it's in the low 300s. So, and then the lead water line replacement, they have some grant money, and they also have low interest WIFIA loans, and everybody's paying that. And I don't know if they've installed this yet, but I'm thinking by fall there will be another $5 charge. It's called, what is it called? I don't know if it's called a lead line replacement fee, but that's what it is. If everybody pays the $5, because the city, really neglected to deal with the lead lines before, and it's gotten so expensive that I think most people that have been here for a long time can't afford to pay what it would cost to replace that. So.
Well, the only quick question I would have on this, or just would want to keep an eye on, is folks who were interested in doing this but aren't needing a certification, and then what does that do for creating sort of even more, like, is that a weed, is that a grass, they have a sticker, they don't have a sticker. So is the certification, again, I'm not disagreeing that it's a good idea, especially
No,
for
I
people
agree.
who
That's a
want
very
it,
good
but it
point.
would be also another way to sort of pay to keep code enforcement off your lawn. So, you know what I mean? Like, I may choose to not want to certify, we are going no water on our property, you know, but I may not want you to tell me what grasses I am putting on, you know, as the ones that would certify me versus what I've chosen to do. So I'll take my chances with the door tag.
One thing that.
Part of what we're thinking is, 0 to very minimal changes in code. So for example, if you had a pollinator garden in your front yard and you kept all plants below 6 inches, you don't need a certification if it's nice and neat. If you let that pollinator garden go to heck and it's full of 6-foot weeds, then code enforcement looks at it and says that is, you know, that's blocking the sidewalk or it's blocking the street. So your point's well taken. But yeah, I mean, theoretically, if you said, I don't want certification, but I will stay within code, then you're gonna have low-hanging plants or grasses, but you'd be legal if you did that.
I don't want to see Inglewood go to one of these cities that has all gravel or rocks in their front yards. That upsets me. I think it raises the temperature within the community because it does reflect the heat. And they've shown that our roads and our cement and all of that has done that. I don't want to see our lawns totally go away, but within reason. So, you know, there's extremes of this, and that's a concern to go to an extreme. So.
And I do think another thing that happened last year, a lot of people let their grass die and just didn't do anything because they couldn't afford to water it.
We let it go dormant. It's not dead.
Dormant,
It's
yeah, it'll come
dormant.
back.
And that does not violate a code, does it?
No, unless weeds pop up in its place, right?
That grow
It
to a
doesn't look
certain height.
good.
Right. Thank you.
Do you wanna leave your discussions about the microchipping, move that to the next meeting?
Yeah, let's do it at the next meeting. I just have not had time.
So, got it, okay. So AJ will do that.
Yeah.
Topics for next meeting. I think we want to talk about that impoundment, the 17185. That we talked about, so if we could add that to review for the April 16th meeting. And what else? Is there anything else? Okay, nothing specific. And where did we leave off? Do you have that annotated where we left off on the review of the?
1541.
Okay, so let's pick that back up too.
Okay.
And that's all I got. And does anybody have anything else? Meeting adjourned.
Thank you.
Oh, I was wondering. Heart palpitations?
Yeah, it helps because sometimes.
Never
Everything's so
have
useful.
Oh, okay.
I plan to be in all of them. I have 2
And it takes 2 hours to-
scheduled in February and April.
Good for you.
My days are all.
Which, are you okay?
Yeah, yeah, and I
Oh.
look in, just need some more candy before I drive home. Just wanted to stay.
I know.